Apologies. DC traffic is brutal. Michael Greco will be right behind me. Hey, how are you?
Excuse our tardiness. Traffic coming over from the American Bar Association building. And we thought we were allowing enough time, but we didn't. We didn't know how heavy the traffic would be. So what are we doing? Is Regina?
Yeah, I take offense. Maybe she's also taking
Okay, so we're going to go ahead and get started. My name is Carl Levan. I teach here in the School of International Service at American University. Welcome. Thank you very much for coming to this event. It's actually been a couple of months in the works, and we're really excited that we have such an enthusiastic turnout, and we've had media inquiries, believe it or not, from all over the world. So put your best questioning face on when you ask your question once we get to the Q&A session. I teach courses on African politics, political theory, and in the PhD program. And this semester, this year, we have a series of events about African politics. And tonight's event is going to focus, of course, on the rule of law. The Africa Council here on campus. Our next event will be March 25th, where we will have two scholars who are experts on African legislatures speak about local and national legislatures in Africa, and especially how those institutions impact democracy and democratization. So I should say that the origins of this event came from a alumni and former student of mine and a friend of mine, Tim Kaberia. And before I turn it over to him, and he's going to introduce our speakers, I want to give the Student Organization for African Studies, recently renamed Africa Initiative, the opportunity to announce their upcoming event and talk a little bit about what they're doing on campus. Elizabeth?
Hi, I'm Elizabeth Priest. I'm, excuse me, I'm Vice President for what's now named Africa Initiative. So we're kind of a student-run organization on campus who brings in events and panelists similar to the faculty organization. So our big upcoming event this year is the second annual African Ambassadorial Dinner. So last year we had 15 ambassadors come to American University, and ours will be April 16th. So I have, if you'd like to learn more about it or get to know, I have a list, and you can put on your name, or if you're interested in getting involved in the organization, your class, and any questions that you might have. So thank you for putting this event, Professor Lamont, and welcome panelists.
Thanks so much. Mr. Kabira, we want to go ahead and introduce the speakers and maybe describe the slight change in the speakers that we have also. So again, thanks for coming. My name's Carl Levan.
Thank you so much, Professor Levan, and thank you all for coming for this event. Well, mine is to introduce the speakers. First, my name is Timothy Kaberia. I'm originally from Kenya, and Professor Levan is my former professor right here at the School of International Service, and we approached him to get this event started. We were looking to have a discussion of the African cases, and we didn't have a way to really get it out. And when we approached Professor Levan, he reached out to other experts in the field. We got the American Bar Association, we got Mr. Lamoni, who is an advisor to the ICC on African Union and United Nations issues. And we got Professor Bosco here with us tonight. Let me just briefly introduce our panelists. From my left, we have Professor David Bosco. And David Bosco is an assistant professor of international politics. He's a Fulbright scholar and a senior editor at the Foreign Policy magazine. Bosco is a former attorney at Cleary, got his stint in Hamilton, where he focused on international arbitration, litigation, and antitrust matters. He also served as a political analyst and journalist in Bosnia, and as governor, and as deputy director of Joint United Nations NATO project on repatriating refugees into Sarajevo. He is the author of Five to Rule Them. He is the author of Five to Rule Them All, which was published in 2009, A History of the UN Security Council, and his latest book, which is quite interesting, at least from the title, is Rough Justice, the International Criminal Court in a World of Power Politics. Mr. Bosco graduated with a JD from Harvard Law School. He got his master's from Cambridge University and his bachelor's from Harvard University. Next to Professor Bosco is Steve Lamoni, and he's a senior advisor on the African Union, United Nations, and Africa situations at the Coalition for the International Criminal Court. Steve is an international human rights lawyer, and he holds a master's degree in law and specializing in human rights law and criminal justice from the Queen's University Belfast in the UK, and he has a bachelor's degree in law from Makerere University, Uganda. Mr. Lamoni has been advocating for international criminal justice and an end to impunity for over 15 years. He has devoted his career to promoting and protecting individual and collective rights throughout Africa, and to challenging the impunity of gross human rights violators at the national and international fora, in the civil society, and in the research sector as well. He began his career in the war zone of northern Uganda, and we all know about the Lord's Resistance Army and all that, as a human rights monitor. While there, Mr. Lamoni monitored and investigated human rights violations between the Ugandan Army, or the UPDF, and the Lord's Resistance Army of Joseph Kony. He advocated for prosecution of perpetrators of these human rights abuses, and he's been doing this for a couple of years. Welcome, Mr. Lamoni. And today we are also privileged to have Mr. Michael Greco, who is a partner at the K.L. Gates Boston office. He is an experienced litigator with over 30 years, as well as a champion of human rights and the rule of law. Mr. Greco is the former president of the American Bar Association from 2005 to 2006, where he represented the American legal profession around the world. Additionally, he has been appointed to numerous leadership positions within the American Bar Association and the Massachusetts Bar Association. Of greater relevance to this panel is the fact that Mr. Greco is the chair of the Advisory Council of the American Bar Association Center for Human Rights and chair of the Board of Advisors of the American Bar Association International Criminal Court Project, a bipartisan, multinational distinguished board that oversees the ABA ICC project. Additionally, Mr. Greco teaches international criminal justice at the Peking University of Transnational Law in Shenzhen, China. And I don't think we can say anything more about Mr. Greco.
Please go.
And then next to me, yes, we're supposed to be having Ms. Regina Jogu, and the last time I tried to reach her, she was in the parking lot, so we believe she's still coming. Let me give you a brief explanation of how we ended up with Ms. Regina Jogu. Initially, we had we invited the Kenyan mission to the United Nations because we believe that the African cases basically have to do quite a bit to do with Kenya, but we have to be very, very clear that this was not just about the Kenyan cases. We are looking at the general picture of the African cases at the International Criminal Court. We were hoping that we would have Ambassador Koki Muli, but we got one that the ambassador is not available. Much as she had wanted to be here, she could not make it because the permanent representative to the Kenya mission in the UN, Ambassador Macharia Kamau, is out of the country. And the communication that we got was that they could not both leave the post at the same time. And so, for that reason, the Ambassador Koki Mundi could not make it. However, we were fortunate to find Ms. Regina Jobu, who is a Kenyan lawyer, an alumni of this university. Actually, she went to Washington College of Law, and she's been quite involved in a number of issues that affect the African continent, and particularly on the Kenyan situation. She's spoken about the ICC cases in Kenya, about the political leadership, and I'm sure quite a number of people who are from Kenya here, or from Africa, East Africa, rather, they may know who Ms. Jobu is. So we're hoping that she'll be able to join us in a few minutes, because the last I heard from her was she was still on her way coming up here. And that's my brief introduction of the panel.
Thank you. Thank you very much.
Oh, you're welcome.
So David will begin with some remarks.
Yep. Thank you very much. It's great to be here. I'm David Bosco, professor in the School of International Service, and I come to this panel and to this event as someone who's been very focused for the last 3 or 4 years on the International Criminal Court as an institution. As many of you know, the International Criminal Court is a relatively recent introduction to the international architecture. In the kind of pantheon of international institutions, it, I think, lays claim to being the most recent. It was negotiated in 1998 and formally opened for business in 2002. More than 120 states have now joined the court. Kenya itself joined in 2005. Somewhat unexpectedly, certainly unexpected to me, the Kenya case, and more broadly speaking, the African investigations that the ICC has launched, have become extremely controversial, and in many respects have become a central challenge for the International Criminal Court moving forward. Some serious observers, diplomatic observers that I've talked to, have even suggested that the Kenya case in particular at this point poses an existential challenge for the court, and that could even threaten the eventual dissolution or marginalization of the ICC. So what I'd propose to do here in my very brief comments is to try to sketch out a little bit how we came to this point, how it is that we've had these controversial cases. And I'd like to first kind of provide an outline of the basic facts regarding the ICC's involvement in Kenya, facts that I suspect will be well known to many of you, but perhaps it's worthwhile to kind of review the chronology. And second, I'd like to discuss very briefly a couple of themes that arise from the Kenya ICC interaction and that I think apply more broadly to many of the ICC investigations in Africa and beyond. So the basic background to the Kenya case is, of course, the violence after the disputed 2007 election in Kenya. According to most estimates, that violence resulted in the deaths of more than 1,000 people, with several 100,000 people having been at least temporarily displaced by the violence and the threat of violence. Several key international personalities attempted to negotiate an end to that violence, most notably former UN Secretary General Kofi Annan. And out of that negotiation process, both international and domestic, emerged a high-level commission of inquiry known colloquially as the EAWP Commission. And it recommended a number of different things, but one of its key recommendations was that there be a special tribunal created, which would be a hybrid tribunal essentially, part national, part international, in order to investigate and prosecute high-level perpetrators of that 2007-2008 violence. But there was also an important provision included in the agreement, which was that if the national authorities failed after a certain period of time to set up an adequate mechanism to investigate and prosecute perpetrators, then the information developed by this Commission of Inquiry would be handed over to the International Criminal Court. And after a quite complicated back and forth and several failed attempts to set up a special tribunal, Kofi Annan eventually handed over to the ICC chief prosecutor, who is at that point Luis Moreno Ocampo of Argentina, a sealed envelope containing the names of the individuals that the Commission believed were the leading suspects in the post-election violence. The prosecutor then took with that information, proceeded with his own investigation with the staff at the International Criminal Court, and in March 2010, the court authorized a formal investigation of the violence, and then in preceding months, the court proceeded to issue summonses for 6 individuals. Now, I'd like to highlight a couple of important aspects of the ICC investigation here. First of all, and for those of you who come from a legal background, it was quite important that this was the first proprio motu investigation by the ICC. And what that means is that this was an investigation initiated, launched by the ICC, rather than having been initiated at the request of a government or at the request of the UN Security Council. And for those of us who are quite interested in the trajectory of the ICC, that's a quite important development because, in a sense, that's a kind of declaration of independence or autonomy by the ICC, where it says we don't simply have to respond to what states ask us to do or to what the UN Security Council asks us to do, but we can initiate investigations on our own. That proprio motu power of the court was the most controversial element one of the most controversial elements at the negotiations that produced the ICC in 1998. A second important point is that the judges, the 3 judges who looked at the question of whether the ICC should open a formal investigation in Kenya, were split on whether an ICC investigation was appropriate. 2 of the judges said yes, 1 of the judges said no, that the violence in Kenya, while deplorable, did not, in essence, meet the gravity threshold, or the threshold of seriousness, that the ICC should require before taking a case. So that is, I think, a very notable point. Finally, I would note that when the ICC did issue, essentially, indictments of these 6 individuals, it did so in the form of summonses rather than arrest warrants. And the reason it did that is because it wanted to position the ICC as being in a essentially cooperative relationship with the Kenyan government, rather than being in a situation of confrontation with the Kenyan government. And so the supposition, the working assumption of the court was that Kenya was going to cooperate and that these individuals were going to cooperate with the court's investigation and ultimately with trials. In formal terms, the ICC remains in a cooperative arrangement with the Kenyan government. And those summonses have not been converted to arrest warrants. However, as you'll hear, I think, in the course of this evening, that formal relationship of cooperation has many, many problems. And I think many would say that, describing it in practice, it's more of a confrontational relationship than a cooperative one. And to bolster that point, Kenya has, after those summonses were issued, undertaken a number of different challenges to the ICC investigations, both at the ICC itself, where there have been a number of challenges to the admissibility of the cases, at the United Nations, where Kenya has urged the UN Security Council to defer the investigations, at the African Union, and bilaterally with a number of key partners. Now, the case, of course, these investigations took a very dramatic turn in 2013 when 2 of those facing charges were elected to very high office in Kenya, and that is, of course, Uhuru Kenyatta, who was elected president, and William Ruto, who was elected deputy president, both of whom had been the subject of these summonses by the ICC. That has, to put it mildly, exacerbated the relationship between the court and the Kenyan government, which remains in a very unstable situation at this moment. Let me briefly highlight 3 themes that I think are important arising from this. First of all is the question of the relationship between international justice and justice at the national level. One of the basic assumptions of the International Criminal Court was that the ICC would be essentially a court of last resort, that it would be a place to go when all other options had failed, and the hope was that the threat or the possibility of ICC involvement would prompt national investigations. The Kenya case, and more broadly some of the other investigations that the ICC has done in Africa, I would say complicate that assumption, that the mere threat or possibility of international prosecutions will galvanize national prosecutions. And in one sense, Kenya appears to be a sharp blow to this idea, because the notion of the EAWP Commission and Kofi Annan was precisely to use the ICC as leverage to get the Kenyan government to take steps at a national level. That did not pan out, and it really has not panned out to this day, where there have not been serious investigations of that violence in Kenya. A second theme is the relationship between justice, on the one hand, and political reconciliation, on the other hand. This often gets discussed in terms of peace versus justice. And the question, of course, is whether in pursuing investigations and prosecutions of individuals in fragile post-conflict societies, do you threaten, in essence, the reconciliation that has been achieved? Do you threaten the fragile peace that has been achieved by insisting on investigations and prosecutions? That is a theme that the Kenyan government has hit upon several times in its objections to the ICC case, is that this threatens to kind of undo the fragile peace that has existed in Kenya since the 2007 violence. Other people, of course, believe that this is nothing but rhetorical cover for a continuation of impunity. A third theme, a final theme, and the one really that I'm most competent to address, is the nature of international justice and the concern that international justice is not being administered fairly. Specifically, of course, the issue is the African focus of the International Criminal Court. Now, there's plenty of disagreement about this topic, but there's one thing that is not in dispute. Every full investigation by the ICC has been in Africa. Every person indicted by the ICC has been African. That is despite the fact that there have been serious crimes against humanity, war crimes committed in a number of other places, including places where the ICC has jurisdiction, such as Afghanistan, Colombia, and Georgia, just to name a couple. Now, one should not have the view that the Kenya case is itself the sole determinant or the sole cause of tension between Africa and African officials and states and the ICC. In fact, that tension has long predated the Kenya investigations. When the ICC indicted Sudanese President Omar al-Bashir, there was a very strong, very negative reaction from the African Union, and the Kenya case has really just exacerbated that tension. I think many people would say that the relationship between the ICC and the African Union is perhaps at its lowest point now that it has been. A number of African states have suggested that they might actually withdraw from the ICC. It's a little bit hard to know how seriously to take these claims, but if that were to happen, if you were to have a number of African states withdraw from the Rome Statute, that would pose an existential threat to the ICC, not only because all of the ICC's investigations are there, but also because African states as a bloc are the largest single bloc in terms of overall ICC membership. So the Kenya investigation, the Africa investigations more broadly are a central issue for the ICC and for international justice more broadly, and I think I'll leave it at that.
Good. Welcome.
Thank you.
Traffic was an issue?
Traffic, yes.
Yes, I'm familiar with that. I was late too. So.
That makes me feel better.
Yeah. But David, thank you for that wonderful overview. This sets the table in a very direct way about what we're going to be talking about this evening. I would make one comment about your last point, David, your third theme. When you mentioned that all of the situations in Africa that the ICC has pursued have been in Africa, what must be said after that statement is that all of the Africa situations, except Kenya, have been referred to the ICC by those African countries. Got that point? Okay. Now, before we begin the format of the program, which will be that I will ask questions of our panelists, I want to give Stephen, you the opportunity to say anything by way of introduction as David has, and also you, Regina. So let me stop and ask whether you want to comment on anything that we've heard so far.
Sure, thanks, Mike. I would like to start by commenting on the threat of withdrawal. It's not the first time that you hear of the threat of withdrawal. A lot of you remember that the first threat for withdrawal came in 2009, June of 2009, when the late Gaddafi was president of Libya. And at that point, he was responding to the indictment of the Sudanese president and threatened then that 36 states from Africa withdraw. That was firstly statistically wrong. Then there were only 32 African states. Today there are 34. Of course, the threat for withdrawal has continued at the recent extraordinary summit that I attended in Addis Ababa. It was brought up, but it did not gain any traction because a number of the states parties told of the Kenyan government very clearly that when they decided to sign and ratify the treaty, they never went to Kenya, they never went to the African Union to request for their permission to join the treaty. And at the end of the day, if they were to withdraw, that's a decision that has to be made by their own parliaments. The same issue was brought up at the brainstorming session of the AU discussing the impact of ICC, December 17th to 18th, brought up by Rwanda and Sudan, and it was again dismissed. It will continue to be a threat, but it's not something that is very serious because African states parties know what their commitments to the Rome Statute are. The last comment I would like to make is the essential situation that we find ourselves in. The creators of the Rome Statute during the Rome pre-conference discussed the very situation that we find ourselves in today, namely a situation where you have a sitting head of state being indicted. During discussions of the Rome Statute, a number of heads of state did speak of how senior government officials and military officials were committing crimes dating back to the 1940s. And it was for that very reason that Article 27 was included in the Rome Statute. It's one thing, of course, to have it in theory, and then the practice of having to implement the proceedings against the sitting head of state. I'd like to stop there for now.
Okay. Thank you. Regina, you're somewhat of a disadvantage coming in a little late, but if there's something preliminarily that you'd like to say, do, or you can wait until after I start asking questions.
I think I'll wait.
Good. Okay. Well, let me make a couple of comments before we start questioning. You heard the introduction of my background, but there are a couple of things that weren't included and that I'd like to mention. One is that my son, Christian, is a graduate of American University, and so it's a pleasure for me to be back on the campus and to be participating in this program. So I wanted you to know that. Secondly is that when I was president of the American Bar Association in 2005 and 6, one of my official trips abroad was to Kenya. I spoke in Nairobi. I spoke to prosecutors from a number of African nations on the subject of human trafficking, which 10 years ago was less understood as a threat not only in African countries but in the United States. This past year, the ABA took on human trafficking as a priority of the legal profession. So but my trip to Kenya was very eventful for many reasons. So I have some firsthand observation of the situation in Kenya, which was very different then than it is now, especially after the 2007 and 2008 elections. And the other point I wanted to make is that the American Bar Association has long been a strong supporter of international criminal justice. Going back to the 1970s, the House of Delegates of the ABA, which is like our Congress, 550 delegates from all over the United States and abroad. We meet twice a year, February and August. We debate policy resolutions. We adopt policies. And in 1978, the first policy adopted by the ABA regarding international criminal justice was to endorse the idea of the creation of a permanent tribunal. And that was followed by 5 other policies. Most recently, the policies have had to do with support for the ICC itself, which, as you heard, was created in 1998 in Rome, became operational in 2002. Why has the ABA consistently, for now more than 4 decades, supported strongly the creation of an permanent international criminal court? Simply, from the end of World War II to 1990-91, the promise, the vow taken after the Nuremberg trials that never again will we permit atrocities like the ones that have happened to happen again. Never. That promise, as heartfelt as it was wrong, because the atrocities have not stopped. If anything, they're worse today than they were during World War II. But the climate wasn't right for the nations of the world to come together as they did finally in 1998, 160 some nations going to Rome, Italy for 2 weeks. And in 2 weeks, an extraordinary thing happened. 160 nations and their representatives, and the ABA had its delegation there, coming together to acknowledge the need for a mechanism to deal with the never-ending atrocities. And so the creation of the Rome Statute, which is a treaty and a statute, was not only an extraordinary event, because so many nations came together, it is the first statement of mankind that there must be a mechanism for dealing with the evil side of humanity, which exists. And so the ABA, from 78 to now, has found ways to try to help the advancement of justice internationally. And since the creation of the ICC to now, more recently, and I'm involved in these efforts, and Kip Hale, who's standing in the back of the room as senior counsel to the American Bar Association Center for Human Rights, Kip and I and others at the ABA have been meeting with the leadership of the ICC for the last 18 months. We have had discussions on how some of the efficiencies and effectiveness of the court might be enhanced. The American Bar Association, together with many organizations throughout the world, are offering to share our best practices. The judges, prosecutors of the U.S., the best of the best, and those of Europe and Asia stand ready to assist the court to deal with whatever issues that the court asks us to help address. Now, so the bona fides of the ADA are there. We are not recently to the dance. We've been there for the last 45 years. So it pains me to see the kind of challenges that are posed by the Kenya situation to the ICC. All the other tribunals that you may have heard about, the creation in 1992 by the United Nations Security Council of the Special Tribunal, the Independent Tribunal for Yugoslavia, the former Yugoslavia, because of the genocide that took place during that conflict. 2 years later, the creation by the UN Security Council of the Special Tribunal for Rwanda, followed by other specific newly created courts dealing with situations in Lebanon, in Iran, in Sierra Leone. The International Criminal Court will be the only court surviving after these other courts have been transitioned out. And the transitioning is happening right now. That by 2016 or 2017, there will be no ICTY, Yugoslavia. There will be no Rwanda or these other courts, other than to finish up their work. So the only remaining vehicle in the world will be the International Criminal Court. I submit that the position of the ADA for the last 4 decades in helping to create such an institution and helping to advance it and now helping to protect it, I want you to understand how serious it is, the possibility that the court would cease to exist or would be crippled or hampered by the erosion of its core. And so what we're talking about tonight was referred to as an existential challenge. I think that's right. It's a challenge of the very existence of this institution. And I would ask you, after we finish this discussion and you're on your way home or wherever you're going, ask yourself, can we permit the elimination of the International Criminal Court? That's a question that perhaps our discussion will help you answer as you hear what the alleged failings of the court have been with regard to Kenya and its accomplishments. So I will say no more about the ABA's involvement other than that we continue to have complete confidence in the court and the need for the court, I think, is self-evident. Now, I want to begin by quoting something that I read this afternoon, and this, I hope it doesn't steal any of your thunder, Regina, but it may help you make your points. Because what I read was a speech that was given by the Ambassador and Deputy Permanent Representative of the Republic of Kenya to the United Nations, Ambassador Koki Muli?
Yes, Muli.
Muli Grignon?
Yeah, Muli and you.
Yes, Muli and then Grignon, who couldn't be with us tonight. But I assume that if she had been with us tonight, she would have made the points that I'm going to quote from her speech. And I have a purpose for quoting these two statements. First, she said, Kenya to the UN, April 2013. Mr. President, Kenya fully supports the International Criminal Justice Initiatives, the Rome Statute, and the International Criminal Court, the ICC, not just because we were co-authors of the Rome Statute, but because Kenya believes in the rule of law, justice, reparations for victims, and the necessity to end impunity. However, Kenya strongly objects to the politicization of the ICC and particularly the Office of the Prosecutor. Kenya also notes the selective application of the universal jurisdiction of the ICC and the selective referrals from the Security Council. This conduct undermines the credibility of the ICC and other tribunals and can sabotage national and regional peace, security, and stability. This in turn leads to the weakening of the international criminal justice machinery. I will not read the other parts, but I want you to understand that when we hear from the ambassador to for Kenya, speaking to the UN, about reiterating Kenya's commitment to the rule of law and commitment to the International Criminal Court, one must ask, how genuine are those statements? When, as you will hear as we go through the questions, facts about what Kenya in fact has been doing for the last 3 or 4 years with respect to these commitments that it so eloquently states at the UN. And so keep an open mind about what the court has done and whether whether the court deserves the kind of criticism that has been leveled by Kenya. So in a sense, what we're doing here tonight is hearing the case. And what's important is that, for you to understand, is that the court is not here. Why isn't there a representative from the ICC here? Because the Rome Statute, among other things, urges states parties and others, especially during a litigation which is ongoing, not to comment publicly about an ongoing situation. So it would be inappropriate for the court to have a representative here. In fact, there are critics in the U.S. who say that why is Kenya permitted to try its case in the press publicly when there is a restriction on that they've agreed to? Kenya has signed the statute, the treaty. These are procedural issues that shouldn't get in our way, but nonetheless understand that when there is an accusation and the court itself cannot respond, it is this kind of a forum, a neutral forum, where you will hear statements made about, is that true? Is that accurate? Is that valid? And the last thing I'll comment on is that the reason I quoted the ambassador's remarks is that it is troubling to know that on the other side of the equation are those who in the U.S. who say, well, if Kenya truly believes in the principles reiterated by the ambassador to the UN, then why has Kenya not cooperated with the ICC in the prosecution to provide access to evidence, to documents? No cooperation whatsoever. The interference with witnesses who are willing to testify and then magically they disappear or they are no longer willing to give testimony in the Kenyan situation. The intimidation of witnesses. Who is doing it, and why is it happening in Kenya? Under complementarity, as Professor Bosco said, the ICC is a court of last resort. The first line should be up to the national courts. In this instance, Kenya. Kenya, under the Rome Statute, has an obligation to investigate and prosecute if the evidence is there. What has Kenya done since 2007, the violence? Has there been an investigation? No. Has there been any indication of prosecution? No. What I'm doing is giving you the rhetoric that we're hearing and then giving you the facts about the actions. And I think you have to decide where the truth lies. So with that kind of some controversial opening observation, now let me ask the panelists some questions. My first question is to Stephen. And Stephen, I want you to, first of all, give us your sense of the public support in Kenya, if you wish to, for the current cases that are before the ICC that are from Africa. For example, where do the victims of those situations stand, generally speaking? So if you perhaps just begin by giving us the brief overview of the 8 situations and how they got there and what the status is and what the reaction is in Africa regarding the situations that are before the ICC. Now, I believe there are 8 of them.
Sure. Thanks, Michael. And I'd like to start off from that note. Of course, like both you and David rightly pointed, Africa went to the ICC 5 times, demanding that the ICC should come and look into their situations and conduct investigations and prosecutions. I'm talking situations in Uganda, Central African Republic, Mali, Cote d'Ivoire, and the Democratic Republic of Congo. In all those situations, African leaders themselves went to the ICC and requested for intervention. The reasons vary from situation to situation. The DRC, the judicial institutions were not functioning. In Uganda, Uganda was unable to arrest Joseph Kony and a number of other reasons. In 2 of the situations, you had UN Security Council referrals. In the situation of Libya, you have unanimous support. You had African members of the Security Council, Nigeria and South Africa supported the referral. In the situation of Darfur, Sudan, you had 3 African members of the Security Council. Only Algeria objected to it. Benin and Tanzania did not object to it. Like David rightly pointed, it's only this situation in Kenya where the ICC officer prosecutor basically came and opened up investigations after there had been several initiatives dating back from 2009 where the Kenyan parliament discussed and on several occasions failed to establish local mechanisms and the special tribunal for Kenya. At that time, a lot of you remember that the deputy president of Kenya, currently William Ruto, was one of the key people saying that let us not be vague, let us go to the Hague. Okay? So since then, of course, Ruto has continued to cooperate with the court. I'll talk about that later on. With regards to public support for the ICC in Kenya, there have been a number of opinion surveys that have been conducted. The latest was up to last year where there was about 50% support of the ICC. That support has been declining for a number of reasons, and I'll outline to you why that support has been declining. Like Michael, you rightly said in your opening statement, the Kenyan Deputy Ambassador talked about their support for international justice, supporting the rule of law, and the ICC, and a number of things. I would like to start by looking at it from 2 sides. It is true to a certain extent that the Kenyan government has been cooperating with the ICC in terms of allowing ICC staff to go into Kenya and conduct investigations, allowing the ICC open up a field office where they can operate there. However, as a number of you will have observed at the recent Kenya Status Conference, there have been 3 main challenges that the Office of Prosecutor and the ICC continue to face. Michael has touched on some of them. I'm going to talk about them in detail. The first threat continues to be witness intimidation and interference. In a recent filing by the Office of Prosecutor, she did mention that this level of witness intimidation and interference is unprecedented. To date, the Office of Prosecutor spends 80% of their time, which is dedicated to looking at the Kenyan cases. The Kenyan case has become a moving target because of this intimidation that has impacted their investigations, where in the past they have collected statements from victims. The next minute you find these victims or witnesses coming up in an affidavit saying that they cannot go ahead and testify against the head of state, their own head of state, because there is the threat from their community that will come back and hit them. The intimidation has gone as far as Kenyans who are out in the diaspora. One of the witnesses that recounted evidence from the United States, others are in Europe. So this is a very highly unprecedented level of intimidation. Also, getting new witnesses is becoming problematic because of the fears that I mentioned, and yet at the same time you have the officer prosecutor getting evidence or testimony from victims, and they need to link this evidence that has been given. Because of the climate of fear, it's becoming problematic, despite the fact that the prosecutor continues to conduct investigations. Lastly, there's been a fear campaign against civil society organizations through the social media and in other cases where you have human rights activists that have been intimidated or threatened by supporters of the government has done nothing. Mike also talked of the records that are needed to corroborate the evidence that's been given. A lot of you remember that last week during the status conference, the issue of government obstruction was clearly painted out in the media. The OTP has requested for evidence for the phone records from the president, judicial records, and records of helicopters. Of course, the Attorney General gave a reason saying that they have no obligation to cooperate with the prosecutor. And yet you have to note that this is a very nonsensical argument because for the past 2 years, the Kenyan government has been selectively cooperating with the ICC in providing some of the records. Why is it at this point that after the officer prosecutor has filed a complaint of non-cooperation that you find that the same government official is claiming that they have no obligation to cooperate with the officer prosecutor? The last point I would like to make on that issue is that, of course, the ICC is perceived to be an enemy of the people in Kenya because the ICC needs to cooperate with other states, parties in Africa, either to relocate these witnesses or victims to other states or get evidence. Now, because of the whole politicization of the Kenyan case, a number of states, parties in Africa are saying that they're willing to cooperate with the court, but not as far as the Kenyan case is concerned. This goes further than the African state because of the whole rhetoric that has been painted right from 2009 from the Omar Bashir case that the ISIS is an imperialist and racist cause. You have other states outside Africa not wanting to be associated with the ISIS, so this continues to be a continuous problem. The last point on the issue of victims, the legal representative of victims for cases in Kenya have been very clear that the victims in Kenya have been demanding for justice and saying that there should be no delay for victims in Kenya. The accused persons should be held accountable, and this is something that was echoed very clearly at the ASP 12 in November, where you had the legal representative of victims and other Kenyan civil society organizations come up and say that they want justice to be done, and the discussions at the AU blatantly leave out the issue of victims. So victims in Kenya definitely want justice.
Okay, thank you, Steve. Regina, I'm going to ask you a question. And I'm going to give a little background on the question.
Sure.
The background is that Kenya, during the years 1997 to 1998, was a member of the UN Security Council. Kenya at that time voted in favor of UN Security Council Resolution 1207, which calls on all states to cooperate fully with the International Criminal Tribunal for the former Yugoslavia, including to comply with its requests for information and investigations, and to otherwise, quote, cooperate fully with the prosecutor in the investigation of all possible violations within the jurisdiction of the tribunal. We're talking about Yugoslavia tribunal. Kenya voted in favor of what I just read. At that time, the ICTY, Yugoslavia, was handling cases of the most senior leaders in the former Yugoslavia, including then head of state Slobodan Milosevic, who was indicted a year later, in 1999, and tried in The Hague prior to his death. Now, my question. Can you explain why Kenya would once support criminal accountability for heads of state in 1997, 1998, but now takes the position that sitting heads of state should be immune from prosecution? That's the question.
Thank you. First of all, I would like to clarify that I'm not representing the government of Kenya. I am not speaking for the government of Kenya. I'm a private citizen, Kenyan citizen, US citizen, and everything that I'm going to, my opinions here are my opinions. Now, coming to the question, when you talk about former Yugoslavia, I would like to say that the Yugoslavia case and the Kenyan case are not the same. The former Yugoslavia case is unique in its history, background, scale, and dynamics. I'd rather focus on the specific reasons why the Kenyan government has taken the position that it has taken, to my understanding and in my opinion. I have a few points to make on that issue. Number one, there has been a big concern about political interference, outside political interference, by parties and non-parties on the ICC. That concern is not only a concern of the Kenya government. It was indeed the reason why the US did not ratify the Rome Statute. They were very concerned about that. Israel, China, and India share the same concern. And in the Kenyan case, from what we've seen in the press, there has been a big concern that there has been interference, outside interference from the Western countries and the US, which is not even a state party to the ICC. As you know, the European countries provide 60% of the funding for the ICC. Now that financial muscle and that kind of, it is connected to some kind of interference. Just 2 weeks ago, the former prosecutor who initiated this case, Moreno Ocampo, came out very clearly and very boldly and stated that he was under extreme pressure to target two people, the President of the Republic of Kenya and his deputy. Now, if that's not interference, I would like to know what interference is. Secondly, I've had a lot of talk about witness threatening and the Kenya government non-cooperation. The Kenya government can only cooperate with the ICC to the extent that its national laws allows it. Understand that in Kenya we are a sovereign state. We have a constitution and we have our own laws. The Attorney General of the Republic of Kenya and the Kenyans and the President and everybody are bound by those laws. It does not matter if the ICC requires Kenya to do a certain thing that is prohibited by national law. By national law and the constitution, they cannot do it. Just 2 weeks ago, the Attorney General went to the ICC and made a presentation where he said his hands were tied. He could not compel witnesses to go to the ICC and testify against the president and the deputy president when the national laws did not allow him to do that. Under the Kenyan constitution, the Kenyan law are supreme to treaty law. And that's a reason why that happened. Now, the other issue that is totally related to that, I would like to bring to your attention that this Kenyan ICC cases have focused unfairly on the prosecution side. And I understand, I'm a human rights lawyer. I totally understand that the victims deserve justice. But we are not going to be according victims justice by going after the wrong people or by administering a flawed justice. In this case, it is my opinion that the ICC has shot itself in the foot. You understand that under the Rome Statute, Article 66, there is a presumption of innocence. They have not honored that. everything that's going out in the press is that the president of Kenya and his deputy are guilty. I don't speak to that. I have no personal opinion on that. But I think as a human rights lawyer, I believe in the presumption of innocence. Those are some of the hallmarks of a criminal justice system. Presumption of innocence. If you look at the US Constitution and all the great constitutions around the world, we have to pay tribute, homage to that principle of presumption of innocence. The other issue is the process, the flawed process that the ICC prosecutors, and let me backtrack, one of the biggest problems that the US, Israel was a member of a Rome Statute for a short time. They withdrew. The reason they withdrew, because they said that the prosecution had too much power. I personally, my personal opinion is exactly that. The prosecution in the ICC case, in the ICC, under the Rome Statute, have too much power. Now, when they were allowed to come into Kenya and investigate the case, you heard the stories about what the investigators did. They colluded with human rights organizations, threatened witnesses, bribed them, coached them to give false testimony. Why do I say that? If you go to a third world country like Kenya, and you're dangling money in front of people of no means, poor people, people hitherto to this investigation had nothing to live on. These people were offered money. If you've been reading the news, you've seen how much money they were offered. They were offered education for their children. They were offered to be taken out of the country to live abroad. And they went for it. And it has turned out to be such a fiasco. I mean, in the magnitude of 60 plus witnesses withdrawing in a single case, that tells you there's a problem with the process. So that's how I look at it, and that's my view. I think this whole process is flawed. And I think it's okay, it's fine. They've been, the president and the deputy, they've been accused of committing certain crimes. Just because an accused person is accused of committing a crime does not mean they committed it. That's why when we go to court, we have convictions and acquittals. Why do we have acquittals? Because the court ends up ruling that this person is not guilty because the evidence does not prove that they committed the crime. This could as well end up being the case. Another last point I want to make. The Rome Statute says that the most responsible party should be held accountable. In this case, that was not the case. The names that were forwarded to the ICC were 12 names. They ended up indicting 6 people. What happened to the other 6? We don't know. They didn't explain that there wasn't enough evidence. But in my view, the 2 principles following the 2007-2008 election violence were the most responsible. And to go back to what you asked him about the public perception or what the public feels about the case, initially, I think Kenya wanted to go to the ICC and obtain justice. But within a short time, I think we realized we're not going to get justice from the court. That's why Uhuru Kenyatta and his deputy were elected president by the public, while there were still indictees or there was still accused before the ICC. Because even the African Union, when the Kenya Parliament voted to go to the ICC, they went to it expecting, reasonably expecting, and rightly so, that it was going to be an impartial process and that it was going to be, we were going to obtain justice from it. But I think later they realized that that's not the way it was going. And they have every right to withdraw and to register their dissatisfaction with the way things are going. And that's what they've been doing.
Well, thank you, Regina. You covered a lot of points, made statements that I believe are not fact-based and are not supported by people who have intimate knowledge of the issues that you've addressed. But as a trial lawyer, I want to ask you, again, the question I asked has to do with the narrow issue of should heads of state be held accountable in 1997, 98, Kenya said absolutely when it had to do with Yugoslavia. Now, the position, I understand it, is it's a different position, that there should be immunity for Kenyatta and others. So the question is, why the shift? I mean, it's just the principle, not the facts. Why has there been a shift in that position? In the United States, those of us who are old enough to remember, we had a president in 1973-74, Richard Nixon, who, it was said of that U.S. president by an American Bar Association president that no one is above the law, not even the President of the United States. There's no immunity for the President of the United States. And the fact that he was pardoned by his successor indicated that if there had been no pardon, President Nixon would have been tried, would have been impeached, and that's what the law is in the United States. That's what we're accustomed to in the U.S. You can sue anybody. You can bring to account anyone in this country.
Mr. Greco, can I make a quick intervention?
Yes, please.
Do you believe that that's a plausible argument to the rest of the world, given that the United States engaged in enhanced interrogation and there has been no judicial inquiry in the United States, and the United States does not accept any international investigations of U.S. conduct?
Well, David, that's a valid point. The linen in the U.S. is not all clean. We know that. There have been, by that I mean that we know that there are mistakes made that we regret, that I regret deeply. But that's a different issue.
No, but there's
Same issue.
No, go ahead.
Sorry. What I'm saying is that I don't believe that you can make that kind of an excuse on the one hand, and on the other, on the flip side of that coin, exact such a high measure of, just a measure for justice where you are not willing to be touched by the same pole as a nation.
If I may intervene, I largely agree with Michael's analysis that a lot of arguments raised by my colleague Regina are not credible. But to start with the last point, on the immunity of heads of state, the starting point beyond the Rome Statute and the draft Code of African Court of Justice and Human Rights, which, by the way, does not also recognize immunity for sitting heads of state, is that the Kenyan Constitution itself, Article 143, subparagraph 4, if you Google it online, does not recognize immunity for the Kenyan head of state in a situation where the Kenyan government is a party to a treaty that does not recognize immunities. That's the first point. Okay. I agree largely with Michael that the arguments of prosecution of whether George Bush and others are not credible. I will argue that we should hold off prosecutions until the head of state is not valid, does not really hold water, because there are institutions that exist today. I did talk of the African Court of Justice and Human Rights that actually is being discussed and is in the stages of at some point being adopted. But the whole discussion of immunity also is stalling the whole process, because the development now, for me coming from the AU summit just recently, is that the argument being advanced by some states is that following the Assembly of States Parties meeting of November, where the African Union was suggesting an amendment to Article 27 to allow for immunity of heads of state, is that if we want to convince the rest of the world that our heads of state should not be prosecuted for the entirety of their time in power, then we should start by amending our own protocols. Now, you have to understand the implications of amending Article 27. It's not that immunity is going to be granted only to Africa. It is immunity for the entirety of the world. That's the other thing. Then I would like to touch on a few things that Regina said that are very inaccurate.
Okay, before you go there, let me just clarify about this immunity thing that you're throwing around. As I said before, I don't speak for the government of Kenya. My personal opinion is that I don't believe that the president should have gotten immunity. My problem is the process. What I'm saying is that I do not believe that the president should be immune or his deputy. But if subjected to a trial like they are subjected now, it should be impartial, and the process must be credible. I have a problem with the process.
So, if I may, yeah, you just mind me the point that you made. So, presumption of innocence, you say there is the perception that the suspects in Kenya are presumed to be guilty. And that is a flawed perception, and I'll explain to you why. Despite the serious charges that the three accused are facing now, and let me focus on the two, the deputy and the president, they are enjoying all their rights. You will remember very well that Ruto was excused to go and attend to national matters after the Westgate scandal. So they continue to actually be presumed innocent. And remember, most importantly, they are still under voluntary summons to appear. So there is no assumption there that they are guilty. They are still presumed innocent until proven guilty. The other point I would like to touch on, you talked about Article 7 of the Rome Statute, the interference with administration of justice, and you gave only one side of the story. You remember that there is a Kenyan journalist, Walter Baraza, who is under an arrest warrant in the whole entire Kenyan situation for the same crimes, interference with witnesses, intimidation, and bribing them. You talk of the ICC bribing his officials. Where did the ICC get the money? The ICC is having problems with getting money to conduct all these investigations. That is not a correct reflection of these issues. The other point I would like to point out, I spent a lot of my time traveling to Kenya. I was in Kenya in August of 2012, in the run-up to the elections. In my analysis and my interaction with Kenya, what led to the election of the then two suspects was the whole rhetoric that you hear from now and again, that the ICC is a colonial and imperialist institution. I remember very well in August 2012, the mother of the current president did go on national radio and said, the colonialists came after my husband, and now they're coming after my son. Those are sentiments that galvanize support of African peoples when you bring back memories of colonialism, which was a truly very bad event in Africa. This whole issue has been politicized beyond anything. The ICC, you say, is a politicized ICC. A lot of people might not like the decision that it makes, but at the end of the day, we have to remember the ICC is a judicial institution and not a political institution that the AU can tell what to do or not to do. Lastly, Article 93 of the Rome Statute with regards to cooperation, you also cited the Kenyan Constitution. Of course, you rightly pointed out what the Attorney General of Kenya said. My reference point to that is Article 93 of the Rome Statute that talks of states parties cooperating with the ICC, and this is an issue that is before the judges who will ultimately make a decision on that issue.
In all fairness, just may I
Sure.
respond very briefly?
Yes.
On the issue of interference of justice, there have been accusations and counter-accusations from both sides, as you know. The prosecution, the ICC prosecution has accused the two accused of interfering with witnesses, and the two accused have also accused the ICC of doing the same. Now, I think we cannot reach a conclusive answer on that. We just have to wait for the decision of the court because there are accusations and counter-accusations. So I leave that at that. Now, on the issue of money.
Do you honestly believe that the ICC, the Office of the Prosecutor, would intimidate or bribe witnesses?
No, listen, listen. It's not the Office of the Prosecutor that did it. We have the Kenya Human Rights Commission, and we heard this other non-governmental organization in Kenya, the WAKE Commission. They are the ones that did the groundwork and all the investigation upon which the ICC relied. If you remember, Kofi Annan was given the WAKE Commission report in October 2009, and the envelope containing the names of 12 people. So they went and used that as the background on which to base their investigation. So the people that actually did all this is the Kenya Human Rights Commission, which is an organ of the Kenya government, by the way, and a creation of Kenyan Parliament. And as you know, those that are Kenyans here, if you read the news, you know what the accusations have been and what the news have been in regard to that. And some of these witnesses that have withdrawn have come up with concrete evidence that they were coerced and they were coached and where they were coached and what they were told to say. Now, on the issue of money from the ICC is required under the Rome Statute to protect the witnesses. And part of protecting the witnesses is getting them out of harm's way. If they believe that if these witnesses are going to give, if they gave testimony, especially in the Kenyan case, where the accused are the president and the deputy president, they could be harmed, right? If you read the Barasa case to which you referred, those witnesses under the Baraza's case have produced evidence how they were given a lot of money, up to over 100,000 Kenya shillings, to go to Uganda, to go to Europe. They were settled with their children. Most of these witnesses are not in Kenya. They're in Europe. They're being kept in hotels. They're being paid money to pay for education for their children. They're being given money to establish future businesses. All that is in the news. And the ICC, and the prosecution has not denied that part.
Where is this been recorded? Because I'd like to see what you've read about this subject.
Michael, just 1 second, please. We're going to let them finish, and then he's going to call out questions.
We will, yeah.
My last point is this.
I'm saving time for questions from the audience, for sure.
To say that the Kenyan people voted for Guru and Ruto based on rhetoric is really underrating the Kenyan people. I think the Kenyan people had a chance to consider the whole situation of the ICC. And are there people that were influenced by the rhetoric? Yes. But are you going to say that everybody and the elections panned out the way they did because of the rhetoric? I don't believe so.
No, please. The rhetoric that I referred to was the quotation from the ambassador of Kenya to the United Nations, the eloquence of those words, the rhetoric, which are belied by the actions that then I followed. So I would never impugn the right of voters to come to their own conclusion when voting in an election. They are free to hear and decide and vote as they wish. So if I misspoke in some way, I wanted to correct that because, someone, well, anyway, so that's clarification on that. Let me touch on one other subject by asking David to comment on something, to elaborate on something that he said, so that we have, and then we'll come to questions from you all. And it has to do with the peace versus justice dilemma, controversy. Because there are those, of course, who believe strongly that if you are insisting on holding people accountable to achieve justice, that may jeopardize or destroy chances for peace, for reconciliation in a country. So that's the debate. Where do you come out on that? But what is the thinking about it? The Rome Statute and the prosecutor, both prosecutors of the ICC, have made it clear. They say their job is to enforce the statute that was agreed to by now 122 nations. And that statute says to the prosecutor, your job is not peace. Your job is to hold accountable those most responsible for the murder and torture and massacre of millions of people. So my job, the prosecutor says, is justice, accountability. There are those who will say, well, then you're closing your eyes to the fact that reconciliation and peace are at risk. So David, amplify what you said about this dilemma and where do you come out on it?
So I think you've teed it up very well in terms of, I think it really depends on whose perspective you're looking at it from. I think from the prosecutor's perspective, it is not their job to try to understand or anticipate what the political ramifications of investigations might be. They're not well suited to do that, and just as you said quite eloquently, that's not their mandate. Their mandate is to investigate and prosecute. But there is, of course, a provision in the Rome Statute which allows for an international organ to take that kind of thing into consideration, and that is Article 16 of the Rome Statute, which allows the UN Security Council to defer an investigation for up to 12 months, renewable, if it feels that an investigation is getting in the way of a peace process or otherwise somehow poses a threat. And Kenya, of course, has gone to the Security Council and asked the Security Council to use its Article 16 powers. It has declined to do so. So I don't think it's the prosecutor's job. I think in any controversial case, you're going to have a lot of rhetoric about what the likely impact of investigations will be. I don't think you can expect the prosecutor to assess that in any systematic way. But more broadly speaking, and here I'm going a little bit beyond my level of expertise, but I think there is a degree of debate in the scholarly literature about the relationship between international prosecutions and reconciliation processes. And I think all I would say is I think it's complicated. And I think the kind of human rights, international justice line that there's no tension here, that they're compatible, and that in fact if you don't have justice you can't have peace, I'm not sure that's right. Based on what I know of these situations. And so I think it's actually quite complicated on the ground. If I could make one broad point about the debate, I find myself in a difficult position because I'm, on the one hand, fairly unsympathetic to the Kenyan government, which, I tend to believe what the Office of the Prosecutor says about interference with witnesses. I tend to believe the Kenyan government is doing what it can to make sure these cases fall apart. So in the micro sense, I'm not very sympathetic to the Kenyan government. In the macro sense, though, I'm quite sympathetic to the idea that we have a very clear double standard when it comes to international justice. And you have certain countries that have opted out of international justice, and you have certain countries that have decided they're going to be part of it. And moreover, I'm also quite sympathetic to the idea that the International Criminal Court takes into account politics when it decides where to investigate. And so I do not think it is coincidental that the ICC has not opened a full investigation in Afghanistan, where it knows the United States would be very hostile to that, NATO would be very hostile to that. I do not think it's coincidental that there was never a full investigation in Georgia when the ICC knows that Russia would probably be quite uncomfortable with that. And it's also abundantly clear that the Security Council referrals to the court are done almost entirely on political grounds rather than on the level of humanitarian suffering or humanitarian need. I mean, there's no principled way in which you can say, yes, a referral for Libya, but not one for Syria, or Sri Lanka for that matter, that doesn't involve geopolitics. And so I believe there is a double standard in international justice. I think the difficult question for African countries who point this out is, well, what are you going to do about it? If you believe there's a double standard, either you accept it and you continue to cooperate with an institution that you have pledged your support to through the Rome Statute, or you say we're opting out of this system. And right now, I think many African states are trying to have it both ways. They're trying to say, we want to be part of the system, but, well, we may not cooperate and we're not going to respect arrest warrants, and if Bashir comes to our territory, we won't arrest him, but we're not going to leave the Rome Statute. And I think that's a kind of fundamentally dishonest position. And I think, it may come to a point where they have to make a more clear-cut decision about what their choice is on the ICC.
Yes, please.
So, I just wanted to point out another article in the Rome Statute. Like David talked of Article 16, but also Article 53 of the Rome Statute. In a situation when the prosecutor of the ICC is conducting investigations, in a situation, the prosecutor is supposed to look at both sides and the implications of peace and justice in that situation. It's after that the determination that the prosecutor can recommend to the judges whether to proceed with the case or not. So there is that clear provision in Rome Statute, Article 53. I would definitely agree with David on the double standards of international justice or uneven landscape of justice. Like David pointed out, they're members of the Security Council that shield their citizens or shield their allies from prosecutions. For whatever reason, Syria, Russia, Israel, Palestine, and all the situations. Like David mentioned, also Georgia. Now, David's question was, what are African countries going to do about this? There's two ways of going about it. In situations where you have concerns about international justice, the Constitution clearly states that the ICC is the court of last resort. This is an opportunity for African states to conduct fair and credible prosecutions and investigations at the national level to hold suspects accountable. That's the first step they can take. Secondly, with regards to Security Council, you have rotational membership of the Security Council where African members are also members of the Security Council as part of the 15. That is also an opportunity for them to exert pressure on the Security Council and point out these double standards where they exist.
Okay. Regina, do you want to comment?
Briefly, I just think from what David said, I think African countries are reluctant about leaving the Rome Statute. They see the intrinsic...
About leaving?
Yeah,
leaving
opting out.
Opting out.
Opting out. There's intrinsic value in being a member of the Rome Statute, but it's not serving them well. So this is a period where the African continent is really grappling with whether to stay or to leave, and looking at the advantages and disadvantages and weighing their options. That's what I think.
Okay. Well, we have about 20 minutes left. I'm going to open it up to the floor, and unless there's something that I should know about.
Yeah, I just wanted, just before we get into the question and answer session, which Professor Levan will take charge of. As a matter of protocol, we just wanted to acknowledge the Deputy Chief of Mission of the Kenya Embassy, Ms. Olesein. We're happy that you're in the audience. We just saw you and thought we should acknowledge you.
Yeah. Please raise your hand so that we can do that. Yeah. Okay. So, do you want to participate? Or
why don't you go ahead and field questions? And I also want to thank Regina and Jogu for coming on rather short notice after Ambassador Muley was unable to attend as we previously expected and planned. And we do need to vacate the room at 8 o'clock promptly, so I just want to make sure that people are precise and parsimonious in their wording, please.
Yes.
And please identify yourself. Thank you.
Yes, I want to add thanks to Regina for pinching at the last minute and coming in not knowing what to expect, and I hope I wasn't too hard, but I'm a lawyer accustomed in the courtroom to asking questions and following up with questions. Good. So, so many hands. So let me start with that gentleman, and then we'll work our way this way. Yes.
Toby Cadden, I'm a British lawyer, and I was previously on the Kenyan defence team. My question would be, assuming that the case collapses, because it's on the verge of collapse, where is the ICC going to find itself then? Because it hasn't exactly covered itself in glory up until now. So this would be a disaster for the ICC PR-wise. So really, where would the ICC go?
Where would the ICC go if the case is tried and lost?
If it collapses before
it collapses not because of the withdrawal of Kenya from the ICC, but because of the failure of evidence.
Through lack of evidence and through the prosecutor not taking the matter, which is a possibility.
It's a possibility. Well, you're aware that on December 19, 2013, the prosecutor requested of the pretrial chamber a continuance of the trial because, among other things, one witness has refused now to testify, and there's evidence that there was tampering with that witness, threatening so that he is no longer willing to testify, and so he's been taken off the witness list. And there was another witness, similarly, no longer willing to risk, apparently, testifying. So the prosecutor has asked for additional time to address the lack of those two witnesses. There are others out there, and so that decision by the chamber, the trial chamber, is expected. We don't know when, but it relates to your question, Toby, which is the court may deny the request for a continuance of the trial, or may grant it. But your question is a valid one. What would happen if the case collapses? Let me posit, and you answer, anyone else on the panel answer it. What if there's a trial and Kenyatta is convicted after a fair trial? What would the consequences be on the peace versus justice issue in the African countries? So we have both possibilities. Collapse before trial. The trial actually takes place because there is evidence and cooperation and so forth. So I look to you two gentlemen, because you both addressed the peace versus justice. What would the impact be in Africa after conviction?
Let me start with Toby's question and I'll come to you. I think your question basically will be a decision that will be made by the judges after they examine the evidence that has been brought by the prosecution and the defense has done its work. At this point, it's really hard for me to say whether the ICC cases in Kenya would collapse or not, because the prosecution continues to conduct investigations and look for witnesses, new witnesses to basically beef up their case. But also that would depend on the cooperation of the Kenyan citizens who are willing to come up and testify as witnesses in the cases in Kenya. If the trial basically concludes with a conviction in the Kenyan case, this would basically be sending a strong statement in support of justice for victims in Africa who have been demanding for accountability, and also would send a signal that no one is above the law in Africa. This would basically actually beef up Africa's image as a continent that is getting rid of its past with all the conflicts that are taking place. But also the last thing I wanted to clarify is that there is the misperception that Africa is on trial. I would like to point out very clearly, like Kofi Annan has said in the recent past, it is not Africa that is on trial, it is individuals that are alleged to have committed crimes in Africa that are on trial.
Okay, next question. Let me go to the other side of the room, this gentleman, and then we'll go back and forth during the remaining time. Yes.
My name is Patrick Dare, and let me just start by saying that there has to be some absolute presumption of innocence until they're found guilty, the two principles. And I think on the other side also, we cannot really brush a lot of this newspaper readings and whatnot reports, because I don't know at what point it becomes a street word that becomes a newspaper reading, and they all become a mixed ball. So unless you have very, evidence, I don't think some of the things that have been said should really have been said. I'm not a lawyer, but I also know that there is what, in terms of in law or in prosecution, there's also protection of witnesses, which essentially takes these witnesses out of their own normal life and puts them in a different format where they have to be supported some way or another. Now, when you go back into even what is happening right now in Kenya and the historic Kenya system, we know that right now in Parliament in Kenya, there are laws that are really regressive, both in the communication side, the media side, and totally trying to stifle the human rights movements and the civil society. So really, there's a lot of things that can be brushed that I really don't think that can be brought in here. But one thing that I would ask you is whether, and this has been mentioned several times, the perception. When something is said over and over and over, if you call a thief, you're a village thief. Even if you're 20 miles away and something gets stolen, you're still the village thief. the perception. And I think the perception that the ICC has given is a level of incompetence, if I may say so. Because, again, the perception of the people is this big Goliath, supported by the US, supported by the West, whether true or not, but it's perception. And they're coming down on this small country, on this poor people, and they want to jail our leaders. And there's, I think, from my perspective, the readings and whatnot, there's a level of maybe incompetence, because the perception of the people, why do you have to keep postponing things? If you don't have enough evidence, then why don't you just say you don't have enough evidence and let the people go? So how do you address that?
Yes?
I think that ties to the question that was previously asked and he answered very well. But I would say that if the cases before the ICC collapsed or there was a successful prosecution of the cases, either way, the ICC's image is dented because of these cases, the flaws and the weaknesses and all the problems of the ICC have been exposed. And what the ICC will need to do is to address these problems and redeem itself. That's my opinion. And the perception out there is that the ICC has all these problems. They've been exposed. They were there, but because of this case, they have been exposed. However way it turns out.
I really don't know whether you want to say exposed, because exposure means that you have evidence that they've done this. I think it's just a matter of word in the street that the perception that they've done that. So I don't know whether you want to use the word
Perception
exposed.
is created by what people have been fed with.
Okay, and there's been a lot of force feeding going on in the last couple by some anyway. Back of the room.
I just want to make a minor point because I don't want to take away the Kip Haley idea. I don't want to take away from other questions. But to the gentleman's comment, which is an incredibly good one, what needs to be understood, though, unlike national jurisdictions that have power over police to go do these things, ICC works on cooperation. So if their cases are falling apart, it's because cooperation isn't there from the states. Isn't there from the states to help facilitate summons, requests for evidence and such. So when we hear the fact about incompetence, I understand that that's a perception. But in reality, ICC doesn't have a police force to go out and do these things. So it has to rely on the states. So that's just one minor point I wanted to correct.
Mm-hmm. Right. Okay, this gentleman.
Yeah, Rob Lord, I'm a master's student in SIS, studying transitional justice. And I have one question for Professor Bosco and one question for Ms. Njogu. Professor Bosco, in Rough Justice, you talk about the 4 anticipated or potential state behaviors that we'll see toward the ICC. And Ms. Njogu mentioned one is that European money has influenced the prosecutor. So the question for you is, to what extent has Fatu Bensouda's or the Office of the Prosecutor's independence been compromised? And in what way? And for Ms. Njogu, I think we've talked a lot about the balance between peace and justice. What reconciliation techniques, what peace is being sought in Kenya right now and how would an ICC prosecution or the continuation thereof impact or negatively affect those reconciliation methods?
Okay. There's so many people who want to ask questions, and for you to ask 2,
Feel free to address either.
choose which one you want answered.
The second one, sure.
The second, okay.
Right. I think your question was about the money that the European. Okay. Understand that, as I said, they provide 60% of the funding for the ICC, so they fund the operations of the ICC. I mean, a bulk of the operations of the ICC, and they also help pick the top members of staff of the ICC. Actually, they influence a lot who the top prosecutors and the judges are, and that's where I see the influence. Now, on the issue of peace and justice, actually in Kenya, after the 2007 and 2008 violence, there were many steps that were put in place to address the issue of peace. But I will quote one of the most highly quoted Kenyan political pundits, Mr. Mutahinguni. This is exactly what he said. He said that immediately after the violence, Kenya lost about 1,300 people died due to the actual violence. But the ICC cases will actually cause more than 10,000 deaths. I believe it. We have already started seeing it. People disappearing, people being killed, and I'm not blaming either side. I think some of the blame goes to the state and to the handlers of the two accused that are intimidating witnesses and whatever is going on. So it's imperative that if Kenya decides that they want to pursue the cause of peace and justice, and of course, because Kenya has already subjected itself to the jurisdiction of the court, withdrawing at this point is next to impossible because the process has already begun. But it can be done simultaneously, in my opinion. We can go ahead with the trial, but we can also pursue steps towards achieving lasting peace.
Okay. We have about 7 minutes. But Steve, did you want to say
Very,
something?
very
Go
quickly
ahead.
on the perception issue. I just wanted to point out, of course, the ICC has a whole section, public information and documentation section, that exclusively deals with public information and outreach, that is work on that. But also the African Union level, they've had 2 technical seminars to try to address the perception issue with the legal advisors. Hopefully they're going to have a 3rd one to address that issue. But perception also could be flawed. I'll give you an example. I worked on the ICC case in Uganda. Now, some of the perceptions from the communities concern issues of prison conditions. For example, there was a perception that if you prosecute the LRA leaders and you take them to the Hague or a host country, they're going to enjoy standards of a 5-star hotel. So you should instead imprison them in Uganda, where the conditions are very difficult. Now, that perception is flawed in the sense that the court has certain standards for whoever is convicted. They have certain standards, okay? That's the same thing with the whole perception of the targeting Africa, which is flawed for a number of reasons that a number of you have already had. So perception could be flawed, but it's a work in progress that the ICC should continue to address with sufficient funding that states parties should provide. Again, I like your intervention, but I just wanted to correct one thing. I do know that for a fact Japan contributes over 20-something%, so I'm not very sure about the 60% you're talking about that comes from Europe. And also, in terms of the selection of the senior government officials of the ICC, you must know that the AU has a whole committee on selections, where every time that a position comes up in an international organization that the AU wants to have influence, they do nominate candidates. Point is 2011, the AU nominated the prosecutor. They'll continue to nominate African judges to senior positions at the ICC and different organizations. So I just wanted to put that in the record.
And the prosecutor, Fatou Bensouda, is from what country?
Gambia.
That's fronted by the EU.
Yes.
Yes.
I have a very quick question. This for Professor Bosco.
Okay, quick question.
Now, we remember Johnny Carson with choices have consequences. And we know that President Kenyatta is coming to Washington in August. Are there still consequences?
Is that confirmed that he's coming to Washington?
He is among the African leaders who've been invited to Washington.
I mean, it's difficult. It's a difficult choice for the U.S. because, and you know, the British, David Cameron, the Prime Minister, met with Kenyatta. But it's difficult because Kenyatta is not in the same position as Bashir. Bashir is subject of an arrest warrant. Kenyatta is subject of a summons, and he's formally, again, cooperating with the court.
But they also said they were not dealing
they
with
did say
indictees.
He's presumed innocent. He's just an accused.
Yeah. So
I don't know what's going to happen.
I was pointing to you, so if you have a quick question.
Yes, I do. Isn't Scott Charney, AU, SIS, foreign policy alum at Masters? Okay. Isn't a lot of the controversy, whether it's about the ICC in particular or international jurisprudence in general, really because it's victor's justice? It certainly was in Yugoslavia. Efraín Ríos Montt, the Hitler of Guatemala, got off on a technicality. No Contras are in the dock anywhere. And certainly no Israelis or Americans, so that would be taboo, unthinkable. Isn't that what all the commotion's about? It's just victor's justice? Hell, it was in World War II also.
Mm-hmm. So anyone want to comment?
Well, my comment to that would be an argument that you advanced before the ICTR. As you know, that the ICC was set up to be able to investigate and prosecute cases in ongoing conflicts. So you need to point out to me which of those cases the 8 of them are victors' justice. But I also mentioned that in some of these situations, you have governments recommending some of their opponents to the ICC.
I've been on this side of the room. I have to go to the others, or maybe in the center. Let's start here and then over to the other side.
Yeah, quick question. I was just wondering, do you guys think it was a mistake for the prosecution to be housed in the same building with the other side, with the judges of the ICC, and to Regina Jogo? I want you to explain why you say that the Kenyan election was kind of like a referendum. Kenyans decided that they don't want this ICC process, when we as Kenyans clearly know that it was a tribal vote almost to the man. You know, like in America we have red and blue states. In Kenya we had dark red and dark blue states. So I just wonder why you're bringing that up, because we clearly know that the tribal election had nothing to do with the ICC. Whichever side, whoever was accused, they would have gone the same way.
To your first question, repeat it please so that we'll see who.
Prosecution being housed in the same building with the judges of the ICC appears like they're all on the same side working together. Do you think that was a bad decision when the Rome Statute was created? Should they have been separated, maybe taken to a different country, and the judges placed in a different country in Europe, just to give the perception of fairness? Because a lot of people who don't understand the ICC feel like maybe Bensouda and Judge Osuji go eat lunch together.
It's very basic when it
No, I don't think it's a problem. I mean, again, maybe there's a perception of a problem, but I know that there's absolute division. In fact, there's tension, which is a healthy tension, between the office of the prosecutor and the chambers, and even the registrar. Those three, under the Rome Statute, each has independence, and boy, they exercise that independence. Yeah. So on the outside, it may appear, gee, you know, maybe they have lunch together and they chat. On the inside, they go their separate ways, number one. Number two, the tension that is healthy, that exists, is in the Rome Statute, because the prosecutor, even when she wants to initiate an investigation, cannot do so until the judges approve it at the pretrial chamber level. So, no, I don't think it's an issue. There are many other things I could point out in the Rome Statute that provide checks and balances, checks on the power of the prosecutor. I mean, I've heard several people say, you know, the prosecutor has too much power, and untrue. I teach this course on international criminal justice in China, and we go through with the students comma by comma of the statute. And we see where the prosecutor does not have power, or if it has authority, it can be overridden by the judges. So, but that's a whole nother program. And we're close now. In fact, we're at the bewitching hour. Is there one really compelling question? Raise your hand.
It is compelling.
Okay. Where am I? This side of the room. Okay, you get the last
My
question.
question is this. I'm Catherine Wanjiko-Richard. I'm a Kenyan living in Washington for about 25 years now. Here's my question. Is it possible, and is it within, so like for Uhuru's, or the accused, their lawyer, can Ocampo be subpoenaed and brought to the court, put to the stand, and asked to just really expand on his recent comments that he gave to the media in Amsterdam? You know, because if it's true that he was being pressured, felt a lot of pressure from ambassadors or whoever, or Western diplomats that he could not mention on camera, but yet those conversations did take place. Can he be compelled so that we can all, well, not we, but so that this justice process can see the full picture? That's my question.
Well, so the question is compulsion. He voluntarily could speak, of course, and I have a feeling of what he would say, but that's my own feeling. But the question is, can he be subpoenaed? So, gentlemen, or
I imagine there's a privilege probably that would apply in that situation. I don't think the prosecutor's office would be required to disclose their internal deliberations, but that's my hunch without it being necessarily taken.
I I think Kenyatta's lawyers have already indicated that they're going to subpoena him. That, of course, will be decided by the court. It will be within the rules to do so.
Stephen, do you have a view?
I have no view. I haven't read his comments after his traveling, so I have no view. I haven't looked at the wrong statute to try to find out if there's some provision.
Me neither. I think I need to.
Yes, in the back.
I just wanted for the benefit of everyone knowing that quote because I thought it was a very interesting comment, and so I looked it up.
What quote?
This is the quote that she was referring to, and I just wanted to read it out. There were some diplomats asking me to do something more to prevent Kenyatta or Ruto to run in the elections, and I said it's not my job. Judges in Kenya should do that, and if they authorize them to run, people will vote. And if people vote for them, we have nothing to say. My perception of that comment is that isn't some sort of undue pressure on Ocampo to pursue these cases. If anything, it's a comment saying that it's outside of his purview. So I just looked it up and
Well, thanks for that. And what it says is that we have to be very careful in making comments, all of us, that are perhaps not all four corners correct. So,
I want to thank the I want to thank the American Bar Association. It's been great working with them and pulling together this event, and also working with the Student Africa Initiative that really helped promote this event. And there's also a new diaspora organization, East Africa Washington Program, that helped come up with the idea for this event, and it's been great working with them. My closing comment is that Mwalimu Julius Nyerere, in his commentary on democracy, and what is democracy, and he was the first president of Tanzania, he said, you have to be able to respect dissenting views, and I just want to say that I'm really impressed by the discourse and the decorum and the debate in this room tonight, so this has really been a great education for all of us.
Thank you for those comments. I want to ask you to join me in thanking our panelists heartily for their participation. I also ask you to give a round of applause to American University for making this program possible. Thank you and good night.
Oh, sorry.
I have pictures.
Okay.
How about you?
Can I use Michael and Tina.
Salam naman. Salam.
Don't worry, I was just calling. Like, is there going to be like a fight?
No, I was thinking you're beautiful. I was thinking you're beautiful.
Well, my father was a cameraman.
Boss, niambie. Hapo ulikuwa wapi? Nilikuwa hapa kwa kona. Hii room ni ndogo.
I know. Well, I thought
They would have gone after them. So how come nobody has been? It's interesting. No one has been prosecuted for writing. The guys are in power. So why haven't they?
I am. Yes.
It has. I mean, the theme of justice and peace is all.